Hello, viewers. Welcome to the fourth lesson of our online YouTube lessons. In today's lesson, I shall be taking you through the qualifications to practice law in Sierra Leone. This lesson is geared towards achieving four objectives. The first is for you to know the pre law school requirements. The second is for you to know the law school itself requirements. The third is for you to know the post law school requirements, that is, after law school. And lastly, for you to know the without law school requirements, that is, those requirements that you need to fulfill even without going through law school. Now, to the first requirement, which is the pre law school requirement, this is captured under section 10, paragraph A, subparagraph 1 to 3 of the Legal Practitioners Act of 2000, Act number 15 of 2000. And these pre law school requirements include that firstly, you must be a holder of a degree in law awarded by the University of Sierra Leone and of such level as the Council of Legal Education may prescribe. Secondly, you should be a holder of any degree in law of a recognized university or other institution of higher learning of a Commonwealth country approved by the Council of Legal Education. And thirdly, one should be a holder of any degree in law of a recognized university or other institutions of higher learning of a country with a legal system analogous to that of Sierra Leone approved by the Council of Legal Education. Please note that a degree in law has to be determined by the Council of Legal Education. So, in other words, the council determines which type of law degree the law school should accept, whether it is an LLB degree, that is Bachelor of Laws degree, or a JD degree, that is Juris Doctor degree. So, the Council of Legal Education determines the type and the level of degree, law degree, that should be accepted by the law school. The Council of Legal Education also has the mandate to determine whether a country practices a legal system that is similar to Sierra Leone. And this is also captured under the same section 10 of the pre-law school requirement. Now, in 2015, the Principal Act of 2000, that is section 10 of this act, was repealed and replaced with the provision that one must be a holder of a degree in law awarded by the University of Sierra Leone, the University of Makeni, and of such level as the Council of Legal Education may prescribe. So, an extension was made to the University of Makeni to allow holders of law degrees to enter the Sierra Leone Law School. Now, to the law school requirement. In the law school, there is a requirement as captured under Section 10, Paragraph B of the Principal Act that one must have passed the appropriate professional examinations conducted by the Council of Legal Education. So, appropriate professional examinations covers the pure academic examinations and even extends to those examinations which the Council of Legal Education determine. So, it might even extend to advocacy, it might even extend to even attending dinners and other professional examinations. Now, to the Sierra Leone Law School exam policies. The first of these policies says that where a student fails two subjects, that student has to sit to those two subjects within a month after the publication of the exam results. Secondly, where a student fails more than two subjects, that is three and above, that student has to sit to the whole examination. Thirdly, every student is entitled to 3 attempts at the Sierra Leone Law School examination. In other words, that one should not attempt the Sierra Leone Law School examination more than 3 times. That is, you are not allowed to go for the fourth time, for the fifth time, and onwards. Now, to the post law school requirement. This is captured under Section 10, paragraph B of the Principal Act. And one of these says that one must have served a period of pupillage of not less than 12 months with a legal practitioner of at least 10 years standing in Sierra Leone. If one could not go under this requirement, there is an alternative that one must serve a period of 18 months, that is 1 year, 6 months, in the judicial and legal service. There are those requirements that do not require attending the Sierra Leone Law School, but permit you and qualifies you to practice law in Sierra Leone. This is captured under Section 15, subsection 1 of the Principal Act. The first says that one must have admitted and enrolled as a legal practitioner in any Commonwealth country approved by the country. And secondly, that one must have practiced law in such country for a period of not less than 10 years, now 5 years under the 2005 Principal Act Amendment. So in other words, that one should not only have been admitted and enrolled as a legal practitioner in another country, that is a Commonwealth country, that person must have practiced for a period of 5 years in that country. And under Section 15, subsection 2, it says that applicant must be a citizen of that Commonwealth country, and that Commonwealth country must have a legal provision that permits Sierra Leonean citizens to also practice law in that country. Now, to the 2004 Legal Practitioners Amendment Act. The following was added to Section 15 of the main Principal Act of the Principal Act. Now, under Section 15, subsection 3, which was added to this Section 15, it says that notwithstanding subsection 2, a person referred to in paragraph A and B of subsection 1 shall be granted an exemption from the requirements of Section 10 in respect of his employment as a legal practitioner, either in the judicial and legal service or otherwise in the service of the state whilst he remains so employed. So in other words, that a person could be exempted from going through the provisions under Section 10, that is going through the Sierra Leone Law School, and also notwithstanding that person being an applicant from another Commonwealth country and having practiced law in another Commonwealth country for a period of 5 years. So in other words, one can still practice law in Sierra Leone without going through the provisions under Section 10 and without also going through the provisions under Section 15. The practice of legal consultancy is also allowed in Sierra Leone, and this is because of the rule established in the case of Millicent against the Council of Legal Education, another 2017. This rule states that a company that offers advisory or legal services with no evidence of its servants and agents not being engaged in the practice of law and not having been enrolled and admitted to practice law but attends meetings of clients does not in any way violate the Legal Practitioners Act by putting or holding oneself capable of offering legal services as legal practitioners. Thank you for listening. Please don't forget to subscribe and also hit the notification bell. Don't forget to also like and drop your comments. You can also follow us on Facebook and like our page. Thank you for listening. Thank you for watching. I'll be right back next time.